Mic stuff set up?
Yeah. All right. So 12 hours and 11 minutes ago, these National Speech and Debate Association set forth a new resolution conceived by the topic committee and intended for all of you to debate. That resolution is resolved in the United States, reporters ought to have the right to protect the identity of confidential sources. During this topic analysis, we're going to go through a couple of things. We'll give you some background information on the resolution. Hopefully, a lot of this background will be review that you will have already discovered doing your own research. Because if you were doing bottom-up research, then you should have a familiarity with the topic literature. Then we'll talk about some of the core affirmative arguments on the resolution, as well as some slightly more advanced arguments, which you could package in different ways. And then the core main neg arguments, along with some slightly more complex arguments, which you'll again be able to package in different ways if you want to. And starting off with background then, is the question, so what is reporter's privilege? Well, in general, privilege is this idea within various legal contexts that certain people cannot be compelled to testify to criminal prosecutors or to a grand jury or to a jury at all if they have certain relations to the source of that information. For example, in most states in the United States, if you're married and your spouse does something illegal, you cannot be compelled to testify against your spouse. Similarly, priests who hear you confess something are not allowed to testify against you. Doctors, if you tell them something like, oh, I got really injured while committing this crime, they often are not allowed to testify. And your attorney, if you tell your attorney, yeah, I'm guilty, they can also in situations be prohibited from testifying. What we're talking about in this resolution is a specific form of the right not to testify, which is that reporters have a right not to testify if someone gives them information on the condition of anonymity, right, or on a condition of confidentiality. So if I knew something about what the U.S. government was doing, and I said, hey, this needs to be public, will you publish this for me, but please don't include my name, I don't want people to know it's me, and you say, fine, I'll keep you secret, what is the information? That's a situation where there's a commitment to confidentiality, and that's the sort of thing the resolution is talking about. Is it actually the case that if a grand jury says, we need you to testify, can I as a reporter be compelled to do so?
Oh, and a few related terms, by the way, in helping y'all research. So you also hear this referred to as journalist privilege. The term confidentiality is going to come up a lot, and shield laws will come up a lot, and we'll explain what those are in 1 second. So, some background. The main legal case you'll probably see a lot in doing research is the Brandsburg v. Hayes case. This is the only time the Supreme Court has actually ruled on the question of reporter's privilege. It was a narrow 5-4 decision in which some fellow named Brandsburg had been doing investigative research in Kentucky on a case of people who were producing marijuana, specifically in this case hashish, which is marijuana resin, and selling it. And so over the course of reporting, he observed people who he was reporting on producing hash. And the question was, before the court, is he compelled to testify against those people? Or can Brandsburg say, I'm a reporter, I'm collecting information on a confidential source, I have the right not to disclose who that was, even if I saw that. And the court in a 5-4 decision ruled that he did not have that right, that there is not any categorical right on behalf of reporters not to reveal, or not to be compelled to reveal, their confidential information. Now, nonetheless, since then, there have been lower court rulings, even at the various circuit levels, that have still found some level of a right or some level of a privilege. And that's going to differ from court to court and from region to region. So, for example, the place where Brandsburg was, Kentucky, the Kentucky, Ohio, Tennessee region, is actually one of the least restrictive in terms of amount of protections they give, but other places have more stringent protections. Nonetheless, none of it since 1972 has made its way all the way up to the Supreme Court. And so the Supreme Court since then has been silent on the issue, and this is the highest level precedent on the matter. One more case worth noting, because I think it also shows up relatively frequently in the literature, is the case of Valerie Plame. This was, it happened in 2003, and the court case was resolved through 2005. And what occurred was Valerie Plame was a CIA operative, and her husband had recently published an article criticizing the Bush administration's decisions in the war in Iraq, saying they went in with insufficient basis. And what happened was shortly thereafter, a reporter leaked information allegedly about her husband, but dropping her name in the article and saying, by the way, this person's wife is a CIA operative, which is information that obviously the reporter should not have had access to because she was a classified top secret CIA agent. And so then the question was, who gave that reporter the information about Valerie Plame? And it came before the court. A number of journalists were called and required to testify. Some actually went to jail for short periods of time. Ultimately, no one was convicted or sentenced, but there was one person, you'll hear the name Scooter Libby, who in the course of the process was convicted for obstruction of justice. And so this is a hot button issue that brought this to the forefront around the 2003 to 2005 area. And so if you see literature in that since then, it's probably going to reference this case because it was a big issue at the time where a major potential political scandal of top-level White House officials trying to deliberately leak information became a core concern that was very politically charged and very highly televised. The next issue is shield laws. These are laws, so congressional statute or state legislature actions that would provide a protection for informants. The court itself might just rule, hey, the Constitution doesn't give you any right to reporter confidentiality or reporter's privilege because that's not grounded in the First Amendment. Nonetheless, the legislative body could then say, all right, even though it's not in the Constitution itself, we want to create that law. We want to make that a law. And so that has in fact happened at the state level in most states. Increasingly many states are providing protections. 40 have a version of a shield law, and most of the others have some level of privilege for reporters to protect them against the ability of the prosecution to compel them to testify. And so even though the law doesn't exist in the Constitution, you'll find many state level governments, almost all of them in fact, do provide some level of protection. Now one issue is that being at the state level, this isn't going to apply to federal prosecution. And another issue is, being 50 different states, they have very different laws that differ widely both in terms of how protected they are, for example, what counts as an exception that could force you to testify, as well as to whom they apply, varying different definitions of who a journalist is and who it does and does not protect. And so the state laws aren't always 100% consistent with each other on that matter, but there is some level of protection at the state level. That being said, there is no federal shield law. There have been a lot proposed. For example, there was a huge flurry of them in the 70s after this big court case where people were like, oh, the court refused to uphold this thing that we think is good. Let's propose laws about it. But even as recently as 2013, there was a law proposed. None of them has actually passed through both houses of Congress, and so it hasn't become law. But people consistently debate this, which is the federal government at the congressional level could create a federal statute that says there is basis for reporter confidentiality and no requirement to disclose.
In addition to the establishment of a federal shield law, there seem to be two other ways discussed in the literature for how the federal government in the United States could establish all reporters within the U.S. a right to this sort of confidentiality. The first is that there could be a ruling on the First Amendment which basically reverses that original 70s case and says, actually, the First Amendment freedom of press and freedom of speech protections do extend to these contexts. And so there are First Amendment grounds for saying reporters have this right to confidentiality. The second and the more commonly proposed move, because it wouldn't require such a radical break with Supreme Court precedent, is that the Supreme Court could rule under Federal Rules of Evidence 501, or 501, that reporters' privilege is a part of common law. So the Federal Rules of Evidence 501 are basically all those things which say, in order to present evidence during a trial, you have to get it in certain types of ways. For instance, you're not allowed to torture someone for evidence. If I torture you and then you tell me something, I cannot present that as admissible evidence during court. If I try to, the judge will throw it out and be like, no, right? You're not allowed to present that anymore. And so changing the Federal Rules of Evidence or reinterpreting the Federal Rules of Evidence to say that there's a common law protection against for reporters' privilege would mean that now, if I as a reporter testify when I had a confidentiality agreement, judges would throw that evidence out. It would be things that we would not be allowed to consider for the purpose of criminal prosecution.
And for those of you who are unaware, what common law refers to is things that are not official statutes. Like, it's not a law that Congress passed that explicitly says this. Common law refers to the sort of legal principles that we've developed over time, e.g., a judge ruled a particular way, then future judges recognized that and cited that in their decisions. And over time, we had a precedent or a consistent tradition of recognizing something, even if there wasn't an explicit congressional rule on it, just because our court system has come to accept that as a basic principle in operation. And so the gist of the Federal Rules of Evidence, Rule 501, is if there is not an explicit congressional statute, e.g. no federal shield law, you could still argue the law specifically says that you should fall back on what the common law principles are. And so a court could rule, even without a congressional statute, that we've just commonly accepted the principle already as a society of reporter's privilege. For example, you could point to the state level laws, the circuit level decisions, and say clearly the Supreme Court, although it was correct in the Constitution, is no longer consistent with the common law that we all now naturally follow, and that's sufficient basis anyway, because the common law, i.e. the sort of principles we accept implicitly, is consistent with the affirmative, even if the explicit rules on the books are not.
Indeed, you don't even need to say there is a common law that says reporters are privileged. You can say our common law principles in general would logically extend to this case, and so our general commitments of common law, for instance, our other principles of privilege, right, prioritize sufficient democratic norms that they should be extended in these contexts as well. So, this raises a question. A lot of questions. What exactly does the resolution mean? Because of these different forms of the AF, there's lots of questions about what all the words can individually mean, and this could change what your affirmative ends up talking about. We've identified what we think are 6 particularly salient questions about how you interpret this resolution, and different interpretations might give rise to fairly different debates. The first one, and the one that has an awful lot of literature about it, is who in the world counts as a reporter? This is especially a serious question when we consider the growth of media which is not produced by major corporations. So the growth of blogs, for instance, or people who post things on Facebook, or groups that post things on Reddit or curate news in those contexts. So if I'm in charge of a Reddit blog, right, where I curate certain sources of information, like, hey, look, these are the new things that are happening, and I do this for the sake of disseminating information to the public, do I count in that context as a reporter? It's really important that we have some notion of who counts as a reporter, because otherwise when we say reporters get these rights, we could be talking about very different groups of people. So some definitions of reporters that are on offer out there indicate that basically everyone's a reporter. I read several articles that made the claim, we're all reporters, because we all tell one another things, right, about the world. Obviously on that interpretation, anyone could tell anyone anything on conditions of confidentiality, and then you could no longer be required to subpoena, right? On other interpretations of what a reporter is, though, it would be very restrictive. It would say basically you have to work for a media company. You have to work for someone like CNN or BBC. In general, in the literature, there are two common positions that are taken. One is the idea that what makes someone a reporter is the function of what they're doing. In other words, what they're trying to achieve. So, if I'm telling you information to inform the public about something I think is really important through my blog, then I take on the role of a reporter. If I'm instead just like sharing my opinions to practice my writing skills, I'm not a reporter. In contrast, the other way to define a reporter is based on occupation. So this is another view that some people have, and generally they identify some rule. It's like you need to have your full-time job be being paid by someone to produce this sort of news, right? Or you need to be employed by a company that receives the tax, that falls under the tax burdens associated with news organizations. Right? Because there's lots of ways that news organizations are sometimes treated differently from other organizations, and so you have to be paid by one of the companies that meet those legal norms. And so you'll have two different groups giving two different broad definitions of reporters. And those are the most common ones in literature. There are also the really wacky ones, like everyone's a reporter. But those are the two main ones. And both seem defensible. The next interesting question that I'm fascinated by is the question of what does it mean for a reporter to have a right? And I think there's two parts here that are interesting. The first is the question of have a right. So I seem to have possession of the right. It's my right as opposed to your right. And the second is what makes something a right versus just something that exists. So some of you will have debated the topic about housing. And that was an interesting resolution, because the resolution didn't say the United States should guarantee everyone a house. It said the United States should guarantee everyone a right to housing. In other words, you could say everyone should get a house, but that still wouldn't affirm the resolution, because you're not saying everyone should get a right to a house, just give them a house, right? And then if you don't give them a house, you're not violating their rights, but you should just do it anyway, because it'd be nice, right? So this raises the question, what does it mean to have a right to something as opposed to just have that thing? So here's a world you could imagine, right? A world in which no reporter is ever asked to testify, is never subpoenaed, right? Is never put on, called into a trial. But if they were, it'd be totally legally okay. It just so happens that all federal prosecutors are like, no, I would never ask a reporter to do such a thing. That's a world in which reporters do not have a right to this sort of confidentiality. And yet, it would be a world in which reporters do not testify against their sources. So the resolution is not just a question of reporter testifying good or bad. It's a question about what sort of grounds does the reporter have to object if you ask them to testify. So when I have a right, different philosophers give different explanations of what rights are. But one common articulation is that a right is a trump, right? A right is a trump card that I get to use and say, no, you do not get to do what you want to do because I have a right against it. So my rights define a sort of sphere that I get to control. And so if I have a right, it's something that no matter what your interests are, you don't get to do the action that would violate it. So my right to property means that you do not get to use my stove even if you make an incredibly delicious meal, right? So if you make a bad meal, you don't get to use my stove because I'll make a better one, right? And so just by utilitarian grounds, I should get to control the stove. But if I have a right to my stove, then even if you make an even better meal than me, it doesn't matter because my right trumps your desire to get access to that stove. And so when we talk about reporters having a right, there's generally this idea that the reporter has a sort of trump card they can play in legal decisions, which means that even if it's a really strong case that it'd be good for the reporter to testify, they get to choose not to. And so this is also generally what we mean when we talk about the reporter having the right. And that's because rights, and this is going to be a technical philosophical concept, which is confusing, and I'll talk more about it at Socrates hours if anyone wants to know more about it. Rights are generally understood to be what's called directed. They are things that we owe to someone. So if Lawrence has a right not to be murdered, then it means that I have a duty not to murder Lawrence. And this is different than other bad things I could do. If I speed, right, in my car, I might break the law. I might do something illegal. But there's no particular person who I'm doing anything wrong to. But generally when we, in legal context, say someone has a right, we say that when that right's violated, they are wronged in a special sort of way. They are harmed. Right? The moral obligation to not make a reporter testify is owed to that reporter in a special sense. And so rights are things that we possess and which make other people owe us particular sorts of actions. So those are all interesting questions and suggest reasons why more philosophical positions on this resolution might be really important. Because it might be a more philosophical position is necessary to argue that we should have a right to reporters protecting confidential sources, rather than just saying prosecutors should not ask them this sort of information.
All right, a few more issues. First is the pesky article the. What does it mean to have the right? And I think you'll find that this could actually potentially be an important term in terms of a few sticky theoretical issues in interpreting the topic. When you say that there is a thing or an object, you're using the indefinite articles, a or an, all that implies that there exists something perhaps among many. E.g., there is an apple on the table. But if I say something like the apple or the debater, it implies a definite or particular set that I'm referring to. So if I said the apple is on the table, it's pretty clear that I have a particular apple in mind, and that statement wouldn't make much sense if we had, for example, hadn't already been talking about an apple, or if there were many apples in the room or on the table. And so the implies not just one of many, but one definite descriptor. And so I think this is potentially relevant, for example, if the app interprets the topic as just being an example of many different possible rights to different areas of confidentiality for sources, and says, I'll defend one of those. Here is a right that reporters ought to have, e.g. the right to protect confidential sources in financial crime cases. And they say, this is a right, this is a good right. The fact that it's a right does not mean it's an affirmation of the right. Because a statement like, the apple's on the table, is not true if there's no particular apple being referred to. And so I think an argument you could potentially make on this topic is that the right implies there is a singular definite right to confidentiality that the affirmative should uphold. And so if the affirmative merely offers an example and says this is one right amongst many and I affirm this one, then they're showing a right but not the right. Next, this cryptic infographic. I'll try to decipher it for y'all. So another perennially tricky topic that comes up in most LD resolutions is that, as with almost every topic before it, this topic has a number of plural terms in the topic that are not clearly quantified. So in this topic, you both have reporters and confidential sources. Both of those are plural. And so the question is, how many does that refer to? And on one reading, a plural term that's not further quantified, e.g. I didn't say two reporters specifically or all reporters specifically, and I left it ambiguous, it therefore refers to two or more, however many, the existential quantification. And this makes sense in some contexts. For example, I said, there are apples on the table. All I mean is there's at least two apples on the table, not that there are all of the apples in the world are on the table, or like, in general, apples tend to be on this one particular table. Just that there's at least two. So that's one way one could read that. Another way one could read something that's plural is literally every instance of that. E.g., if I said, bachelors are unmarried, you probably don't interpret that as, well, there's at least two bachelors who are unmarried. Most of them are probably married. You interpret that as just the definition of a bachelor is someone who's unmarried, and this applies categorically across there. Uh-oh. Marshall? Maya? Emergency. As I was saying, I'll continue this point. Oh, perfect. So a third option one might have is that there's some sort of middle ground of, if I refer to something like ducks have webbed feet, I'm not just saying that there's at least two ducks with webbed feet. Most of them probably don't have webbed feet, but at least two do. And I'm not necessarily saying literally every duck has webbed feet. E.g., if I cut a duck's feet off, it doesn't cease to be a duck. What I'm saying is something more like, in general, ducks have webbed feet. This is a general category or characteristic of ducks, is having webbed feet. And so I think a very plausible argument that many of you all are probably familiar with from past topics that also use similar grammar is that terms like reporters or confidential sources might be interpreted to mean not just any two reporters or literally every reporter, but potentially in general what is true of reporters, and do the rights apply to confidential sources in general, such that not any one particular example affirms or negates the resolution, but both sides are arguing some sort of general statement about how reporters in general ought to behave towards confidential sources in general. And represented by this handsome man who is kind of notorious for this argument. And then lastly, in the United States. So this is a potential question because some of the areas of this topic are going to deal with international matters. So for example, leaks about our foreign policy, or leaks that were garnered from people in other countries. The Valerie Plame example earlier, one of the potential related issues was testimony that a reporter named Judith Miller got from a person in Iraq testifying about the WMD policy of Iraq, and it was used to justify U.S. intervention. And so one question might be, is it an example of a right in the United States if that person is protected? Because she exists in the U.S., she's writing in the U.S., but the person reporting and the information about it is not in the United States. And so you might want to have a good conception of what in the United States means. It seems that, given that the topic is about the right, reporters ought to have that right in the United States, that it's not necessarily a question of where the reporters physically are, or where the sources physically are, or anything like that. It would be more a question of, are they being tried in a U.S. court under the U.S. legal system? Because that is where the right resides. And that seems like the most plausible interpretation, but I imagine people might interpret it other ways.
So, we'll do questions in a moment. So, since that core first court case, there were two real questions that have been the central questions that most of the literature on the topic talks about. The first is this question of how should we, as a democracy, value our concerns with open communication, and in particular, open access the press has to information, versus our interest in judicial access to pertinent and privileged information. So it's not a very good thing when the court can't get access to the truth. Because when the court can't get access to the truth, we risk both letting dangerous people not get prosecuted for crimes they commit, And we risk innocent people getting prosecuted for crimes they did not commit because we're not able to identify exactly who should indeed be prosecuted. And so there's this strong principle of judiciary that we should have access to all the evidence available. In the U.S. tradition, this has been known as the every man's evidence standard. The idea that the court or the state, when it prosecutes, should have access to all the standards, all the evidence that we have available. And that should define, in general, what evidence the state has access to, which is why we generally think that we have a right to subpoena you or to require you to testify if you're a witness to a crime, because you're a part of the public, and so the public needs access to your information. However, this is then constricted, right? And we have to balance this against the interests we have in particular, certain forms of privileged communication. So if we want people to talk to lawyers and be able to honestly talk to lawyers so they get defense counsel, then we might only be able to achieve that if we give lawyers privileged status. Similarly, if we want people to talk to reporters because we think it's important for a democracy to have a free press who can report on issues of relevance to the public, then we might think that it's relevant that reporters have privileged status. And so a lot of the core topic literature pits these two values against one another and tries to assess which one is more important. And you'll find a lot of the affirmative arguments really come down to a claim about one of these two issues.
Another core question in the resolution that Marshall hinted to earlier is there's an important question of who is actually covered under the scope of this discussion. Who is a reporter and who can claim this privilege? And there's at least two possible ways, and either has their own potential pitfalls. So one option is to have a very expansive definition of what counts as a reporter or a journalist, or in essence, someone who's protected by this right. And on this reading, you have a very effective right insofar as it protects many people and definitely doesn't allow particular examples of leaking information to fall through the cracks. But it's so broad that you might end up catching too many examples that you don't want to. For example, any old person could just be like, well, yeah, I'm technically a reporter. I plan on writing a blog about this later. Which means you might end up with cases where someone who has no real legitimate journalistic interest using an overbroad interpretation of what counts as reporting to get out of being subpoenaed or having to testify. Because they say, well, this law conceivably applies to everyone. I'm a person, therefore it applies to me. And so I can use this as an excuse not to testify against, say, my co-conspirators. And so you need some notion of rigor on what counts as a reporter in order to prevent that explosion of the rule such that it applies to literally every case. But then, if you start to do that, and you start to say who is and who is not a reporter, even if you can come up with a good principled basis that isn't arbitrary, like picking out a certain set of companies and being like, these are the real journalist companies, you have the problem of you've now created a hierarchy within the Constitution and within the First Amendment specifically where certain people, the people who are reporters, have a privileged status in terms of their rights to freedom of speech and press. They are now more legally protected than other people, which is both, potentially unprecedented in our law, but also creates, unsavory conclusions about the notion of equal protection under the law. And so you might argue this is a bad legal precedent to set because it relies on carving out who is a reporter, whose profession gives them access to, say, additional speech, and then you have the converse problem of shutting down people on grounds that you're not a legitimate reporter, so you have weaker freedom of speech standards. Additionally, think about relevant controversies in the news about what is and is not fake news. What are real and legitimate news sources? This would inevitably involve the government drawing lines and say including or excluding certain news sources, and then obviously that'll be very politically charged if the government itself is deeming you as a legitimate or illegitimate reporter, and you can imagine that that is liable to, say, political bias or charges of political bias, or the government misapplying the standard in ways that are either intentionally or unintentionally very harmful to the freedom of the press.
So with those core controversies in mind, we can now start looking at particular affirmative arguments.
So a really big one is going to be the chilling effect. I think this one seems kind of obvious. It's probably the first thing you thought of on the topic, which is if there's no confidentiality and the reporters can't guarantee that they're not going to turn around and be subpoenaed and be required to testify on behalf of the government against you, then you're probably not going to share your information. So poor Brandsburg, who just wanted to report about the marijuana industry in Kentucky, won't even get the information in the first place because no one's going to let him in, no one's going to talk to him. And so we destroy the value of the press as an independent arm of society able to research on controversial issues, potentially against criminal activity, against the government itself, or any matter of controversy the public might feel the need to know about, because nobody in any of those controversial cases, e.g. a criminal or someone in the government reporting on government abuse, a whistleblower, is ever going to talk to them if they know they don't have protection. And so we lose access to the very foundation of the freedom of press, which is the ability of those reporters to get important, sensitive information, because there's no longer a protection or no longer a guarantee that you will be safe if you get that information up. And so those sources of information are going to dry up. And importantly, you might not even know if it happens. If you're a reporter and you're talking to these people and they're like, yeah, that's all I had to say, I'm telling you everything. In a world of no confidentiality, they very well might be holding things back because they know that you'll report it if they say something about it. And so we won't even know what we don't know, because in this world you don't know what things are being held back in the first place, and so it's hard to even measure the full gravity or the full extent of the chilling effect, because people might still allege to be talking to you in full honesty and be holding things back anyway.
Another cause of this sort of chilling effect is that every state currently has a different law that tries to shield reporters. And all of these laws work differently and have different norms. And different federal courts have set up different standards themselves. So there's a real inconsistency between what the protections are for any given state. This makes it much harder to navigate the legal system as someone who wants to disclose information to a reporter. It also makes it much trickier as a reporter to go public with information, because it's a lot more difficult for you to figure out what your legal cover is if you were to be subpoenaed. And so there's a lot of arguments that even if a world where there was every state had some sort of protection, because you don't know exactly what the protection is in each individual case, and it requires a remarkable amount of legal understanding in order to know what the particular protections are. The mass indeterminancy that happens when there's not a single right that all reporters have causes its own chilling effect, which can be just as serious. These chilling effect arguments, I think, are especially strategic on the affirmative if you implicate them out in frameworks that talk about the importance of democracy, checks and balances, and other ways in which we want to say that limits on government power are important. Because the main thought that people have is that the reason to have a press in a democracy is that the press acts as what's called the fourth estate. This is a term you'll find in literature. And the idea of a fourth estate is a group that has significant influence on government policy, yet that is not the government. And so if the media can inform us about what the government's doing and reveal causes of government corruption, that might be a necessary thing in order to check back against various forms of government power. Simple checks and balances arguments based on the work of people like Montesquieu can therefore be really strategic, because you can make arguments that democracy requires that we have an independent press, and this independent press requires people willing to talk to and disclose information without fear of reprisal. A slightly more sophisticated version of the same framework can be found if you look up a literature base called Civic Republicanism. So Civic Republicanism has nothing to do with the Republican Party, right? Well, it has something to do because, they both care about republics, but that's a very minimal thing to do with it, right? Civic Republicanism is a political philosophy that talks about the importance of independence, where independence is slightly different than how we normally think about freedom. So we normally think about freedom as the ability to do what you want. But Civic Republicans say that's not quite enough, because you might be able to do what you want just because someone else happens to agree that that's what you should do. So if Jacob holds a gun to my head and says, Marshall, you better go teach a debate camp this summer, I'm going to kill you, I'll be like, okay. I mean, that is what I was going to do. But it's also still the case that I might be able to do what I want, teach a debate camp, but I'm not really independent. It's not up to me. I better make sure that Jacob's happy with me, right? If Jacob gets upset with me and no longer likes me, I'm going to be in trouble. And so what's nice about these civic republicanism positions is you don't actually even need to win the government's going to do anything bad with their power. In the same way, I don't need to win that Jacob's going to use his gun to make me go kill someone or do some work I don't want. My independence is violated just because he has that ability to do that to me. And so Republicans think it's really important not just that the government not do bad things, but that the government not be able to do bad things. And so we need these sort of checks, not because the government is evil, but because the mere fact the government could be evil and we don't know about it is enough to make the democracy insufficient. Another core affirmative argument on this topic talks about the sort of need for the media to be independent of the interests of the state. So there's a lot of articles on the affirmative that talk about how over the last 20 years, we've seen an increase in the use of subpoenas by prosecutors to compel reporters to testify. And a lot of people argue this is really bad because it's allowing federal prosecutors to basically offload the responsibility of research onto reporters and make them do all the work. And you might think, well, why is this so bad? And there are a couple of reasons that seem to be outlined for why this is a bad thing. First, suppose you're the sort of person who doesn't trust the police, and you have good reason not to trust the police. This means that if you would not take information about bad abuse that's happening to the police, and now you think about the media as very closely tied with police organizations, you're now also going to be unwilling to bring that information to the media. But this is a problem, because if you are being exploited and you can't bring that information to legal authorities and you can't bring it to the media, then it's very unclear who you could possibly bring that information to at all. And so between the media and legal institutions, those are really two of the main sources people could go to try to advocate for themselves. And when we get those close together, then lots of communities in the United States won't have anyone they can appeal to try to make change happen. A second worry that's often gestured at, and the reporters seem very bent on, is that it takes a long time to deal with these subpoenas. Now you might be like, okay, so you got to fill out a lot of paperwork. That doesn't seem like the biggest impact, right? And I think the better way to make this argument is to make the claim that guess who really can deal with all the paperwork? Groups like CNN or BBC, major news outlets who have big legal teams who are able to deal with this sort of information. The groups that it becomes a real problem for are small organizations, local news sources that don't have the same sort of legal resources. When they get embroiled in these subpoena questions, it often has a much bigger effect on their ability to report on the news. And if you think that local news is really, really important, and especially local news that identifies local forms of corruption is really important for democracy, then you might think that a lot of these local news organizations' time being absorbed by prosecution is going to undermine our ability to have meaningful checks at the local level, things that CNN and BBC might not notice. There are also arguments you can make for why democracy requires a broad distribution of media. Right? When a couple of rich people control most of the media outlets, you might think that the checks against those individuals are significantly lessened. And so the consolidation of media power could be a dangerous thing for democracy, and it may be that as we offload responsibility for reporting onto media outlets, only the major media corporations are able to handle it.
So, a few more potential concerns. It seems highly likely that many people in the affirmative are going to try to find specific areas of controversy to garner specific impact off of. Happens on every topic. So I expect the most likely way this is going to happen and play out on this topic is people are going to find particular areas of the law that they say it's uniquely important to have confidentiality for. Just a few examples. Whistleblowers in various areas of the government or of the private corporations, e.g. corporate whistleblowers, people on dealing with financial regulations, government whistleblowers. Edward Snowden is an example of a government whistleblower. And other cases like this, where you find a particular sector and you say people who are revealing valuable information about, say, military policy or about corporate abuse need to have special protections against retaliation. And we need the ability for those people to confidentially go to the media in order to get that information to light. And you have an impact, e.g. that checking the government security apparatus is super important, might be a scenario that the affirmative could discuss. So you say, in the status quo, we don't have the ability to get open information about a highly secretive, say, bureaucratic arm of the government, like the national security portion. And you say, the affirmative ensures that that actually comes to light, because now people in the government know that they can confidentially report to a reporter without the fear of their name going public and them getting arrested or otherwise have retaliation against them that would prevent them from speaking up.
Another place people may look for specific affirmative plans is arguments about how there are particular populations that have especially strong claims to confidentiality. One of these that's particularly prominent in the literature is the claim that the way we deal with survivors of sexual assault can often be very callous and harmful. For instance, disclosing names publicly can often do a lot more damage right? Which is why a lot of people, for instance, choose not to go to the authorities or press charges in cases of sexual assault. But a situation in which individuals who get accused of sexual assault are able to demand, via the legal system, in order to make their libel claims go through, that reporters divulge who made these reports, is a situation where there might not be adequate protection for individuals who are trying to bring to light forms of violence that are happening in society. And so there are arguments that say we'll have a chilling effect within society if we're not able to openly bring to light issues like sexual assault, but do so in a way that retains the privacy and confidentiality of those who are coming forward with this sort of information.
Next, another concern, and this kind of dovetails with the one I was discussing a second ago, is you might argue that the sort of norms about whistleblowers are important in challenging the legitimacy or the authority or the overreach of the government. And this is particularly true, I think, in the post-9/11 security environment, where the government has become highly secretive and highly restrictive of rights. Certainly, you all know about the NSA, the TSA, other examples of government organizations that severely are impinging upon rights. And so one might argue that the function of the affirmative is to use the press as a hedge against that sort of government control, and the ability of people to openly report on government abuses of power prevents them from doing things like keeping things classified to keep it out of the public eye, and thereby keeping the public ignorant of, say, NSA surveillance and the ways in which it's being used in a potentially unconstitutional manner. And that sort of information needs to come to light so that we can have an informed democracy that potentially challenges government overreach. And you might argue both that the whistleblowers, in effect, would give us valuable information in that fight, but also that the simple precedent of the affirmative is a challenge to that mindset that we currently have, where our current laws are very clearly situated around protecting the government's ability to secure us, as opposed to protecting the individual's right to secure themselves against the government, and that the affirmative would be a step away from that and towards the proper orientation of the civilians versus the government.
This raises the question then, these seem like decent arguments. What could you possibly say?
Well, there's a few things you could say. So one very common argument. So for example, if you read the Brandsburg v. Hayes court decision itself, this is the argument that the majority made, is just that there is a crucial function of our judicial system and of the trial process, which is to find the correct information and accurately enforce the law. And any sort of privilege that we throw out, especially without sufficient grounding, is going to throw a monkey wrench into that process. If you can just go and say, hey, I don't feel like testifying even if I have valuable information, you are, for better or worse, for whatever reason is, definitely doing something that undermines the trial process. And so if you believe that there's an important function in our government of the trials, or even of the grand jury process, not even the actual trial juries, and that plays an important role, then there should be a very high bar to meet for allowing individuals to subvert that. And so the majority opinion in that court case said, we recognize as a fundamental aspect of society the role of grand juries in ascertaining information. They said the same thing about an actual trial with an actual jury. They would say, this is an important aspect of our legal system, the ability to have a trial that has access to all the information and then produces an accurate verdict. And when you allow people to selectively avoid giving relevant information or in other ways subvert the process, then that's not going to be justified. And so if there's a conflict between freedom of press and efficacy of the trial, then that should take precedent. And you can think of a few examples where it might be obvious that freedom of press or the ability of reporters to get more information is just obviously not going to trump the potential harms to the government system. For example, if they literally just like murdered someone to get the information, they couldn't go up in front of a judge and be like, yeah, I know I broke the whole like don't murder law, but I have a right to freedom of press, and the only way I was going to get this particular information was by killing someone or torturing them or whatever. Obviously, we would think that's a weightier right. And even if there is in general a right to have as open a press as possible, there's going to be some constraints. E.g., you could never get information that involves killing or torturing someone to get it. And so then the question becomes, if we think that the right to freedom of press is not absolute and otherwise can be weightier, is this an example of a weightier right? Is it important enough that we have an accurate trial that subverting that trial is also something so severe, much like torturing or beating someone up for information, that we shouldn't allow that to be violated to get information? And that's, I think, a very common argument you'll see, especially in a lot of the legal articles on this topic.
A second
The second one is you could argue that the affirmative sets the groundworks for abuse of the system. The Valerie Plame case earlier, where it was argued that top-level White House officials, Scooter Libby in particular was one person who was highly involved in this case. Dick Cheney's name was dropped, although they're never charges officially filed. People who were very high up in the White House were being alleged to have deliberately leaked the name of Valerie Plame as a CIA operative as recourse because her husband had published an article critical of the White House and their decisions made in the Iraq War. And there was never an official conclusion of that, so that particular case, unclear which direction it goes, but certainly it shows the possibility, and a possibility that would expand on the world of the affirmative, to use confidential leaks as essentially a political weapon. You could, versus your political rival, go to a reporter and leak negative information about them. So if I'm running against Marshall for office, I could go to reporter Lawrence and say, hey, confidentially, on the down low, Lawrence, you should let everyone know that Marshall likes pineapple on his pizza. And then nobody would ever vote for him. But that's ridiculous. Yeah, exactly. Yeah, see? And that would secure the vote. And, oh no, what have I started? So here's why this problem is doubly severe. Maybe Marshall, like all reasonable humans, doesn't actually like pineapple on his pizza. And it was totally a lie. And he's like, who's spreading this lie about me? In a world where that happens, Marshall cannot go to Lawrence and say, tell me who told you that. I want to prosecute them for libel or slander, because Lawrence has no obligation to reveal a source. So I'm protected even if I do something illegal, like commit libelous or slanderous claims against Marshall, because there's no way to trace it back to me. And so you might argue that an overexpansive right like the affirmative gives people the ability to abuse it in ways like that. This one.
Yep.
So, the integrity of First Amendment. An important question is, how special do we consider the reporters? And an argument we discussed a second ago is, where do you draw the line in terms of who is and is not a reporter? And an important argument by the negative is that affirming can undermine the precedent that everyone has equal access to the First Amendment. Everyone is protected by the rights to freedom of press, freedom of speech, freedom of assembly. And the reason why that's true, as we discussed briefly a second ago, is affirming creates some sort of special right on behalf of the press or journalists or reporters to do things that otherwise people could not do, namely avoid subpoenas. And if everyone's a reporter, I mean, maybe they have argued that. Literally everyone's a reporter, but then you have the problem of the whole court system might potentially break down where anyone can claim the ability to avoid subpoenas. And so if the affirmative doesn't say literally everyone's a reporter and doesn't bite the bullet on whole court system potentially breaks down, then they have the secondary problem of where do we draw that line? You might want to argue that that line drawing problem is very difficult, and even if the line could be successfully drawn, the very existence of a line is problematic because it creates a distinction between the two groups that we wouldn't want to draw for constitutional law purposes.
One way I think to make this argument particularly compelling is to argue that the problem with the affirmative is that it makes it the reporter's right not to divulge this information. But that's not the only way to have a right to confidentiality. For example, with other forms of privilege, it's not the doctor has a right not to reveal my information. It's I have a right that the doctor not reveal my information. It's not as though we do anything bad to the doctor when we make the doctor tell everyone about my illnesses. We do something bad to me. One way to see this is we think the doctor would do something bad if they just choose, you know what, actually I'm just going to tell Marshall's information to everyone. I should be able to insist, no doctor, you cannot do that. So similarly, we might think it shouldn't be the reporter's right to confidential information. Instead, it should be my right as the source of the information's right to confidential information. If I tell someone something on grounds of confidentiality in order for it to be disseminated, then perhaps everyone who does that should have a right that information be treated as privileged. And so here we'd be able to say everyone gets the exact same right. Everyone has the right that if you tell someone else something so that they can distribute it and disseminate it to the public on grounds that it's to be kept confidential, then my right to that confidentiality comes into play. And so we wouldn't have to give reporters any special rights. It's just a right everyone has to tell reporters certain things under conditions of confidentiality. This is probably a specifically strategic argument as the negative to make against some of those particular plan affirmatives we talked about earlier. So it seems like, for instance, if we're concerned about survivors of sexual assault, it's an especially good idea to make it their right that information not be disclosed and be kept confidential rather than the reporter's right. Because if it's the reporter's right, you might worry that the reporter can just privately decide, you know what, this confidentiality is not important enough, I'm going to violate it. I'm going to give away this information. And since it's just the reporter's right, they're allowed to do that. So you might think it's especially important to make sure it's not the reporter's right, but instead the source's right. There also seems to be some evidence, though I'll be honest, I could not find it recently, like today, so maybe I just dreamed this back when I was younger. There also seems to be some arguments out there that it should be the community or society's right that we keep information confidential, and again, not something owned by the reporter. It's not the reporter who has a claim. It's not their right. The reporter doesn't have this right. Instead, the reporter is just bound by someone else's right. A second argument for the negative within this sort of broad realm is the question, why do we trust an individual reporter to be the decider of questions like, what evidence should the court have access to? So perhaps we think it's actually a really good idea that whistleblowers and other people who deliver confidential information to the public be protected from prosecution to encourage them to do that. And we can all agree as a society that's really important. That I come forward being like, look, you have no idea what Victory Briefs is doing when they're charging you for dinner, right? UCLA gives us dinner for free. Not true, right? I wish, right? If I come forward with that information, you might think, yeah, Marshall, even though you were definitely part of this and have been making huge amounts of money off this scam, I have not. It's very sad. Still, because I want to be incentivized to do that, I should be protected and I should not be prosecuted. So we could have whistleblower laws that would protect me, which I could appeal to if I try to get prosecuted. And so the negative could say we should definitely have whistleblower laws. We just absolutely should not make it up to the decision of a random reporter, right, about whether or not this information comes under the whistleblower protection or not. Because there definitely is some things which I should still get prosecuted for, right? And so if we think there are these things, then we think, yeah, we should have these protections and we should have the courts decide who's protected, but it shouldn't be up to the reporter to be responsible for making these decisions. This is an especially nice argument given that a lot of the affirmative arguments that are powerful in this resolution talk about things like democratic checks. But there are no democratic checks of the private judgment of a reporter. There is no public knowledge about whether or not the reporter did the right sort of thing. And so you might think having the discussion, should we prosecute, is better to be had in the open than it is to be had behind the closed mind of that individual journalist.
Next, a few more arguments. So one thing you might have noticed if you weren't living under a rock for the past year and a half is that issues of freedom of press and media integrity have been pretty polarized and pretty politicized in the last year or so. Things like the fake news and issues of libel suits and so forth. There have been a lot of cases, specifically ones attached to the presidency, back and forth regarding the legitimacy of the press. CNN, is it fake news? Who's to say? And so imagine anything of the sort, like what the affirmative is advocating, were to happen in the near future. If the courts were to vastly restrict, or if Congress were to take an action protecting and preventing the ability of people to compel their media to testify. Given how politicized the freedom of press is in the status quo, how closely that is tied to things like the legitimacy or illegitimacy of certain challenges to the presidency, you can imagine that it's going to be highly politicized and highly contentious. And so there's a lot of ways one might impact this argument. But you can imagine, for example, that such a high-profile and highly political decision could have impacts on, say, the midterm elections, or choices of presidential policy, potential backlash from various groups, and action that looks like, say, an attack on the media or a defense of the media, anything in either direction could potentially vastly change the political climate in ways that there could be numerous various impacts to. And so certainly over the course of the topic, you'll be able to find a number of ways that the sort of politically charged effect of challenges to the press could end up materializing harmful consequences.
From a more critical standpoint, there also seem to be negative arguments about how the notion that reporters have this sort of right is going to have this effect of largely creating conditions where if we were to affirm, we'd be creating these conditions where we say endorse all media, right, or say all media is really the same, or other sort of positions where you might think a lot of the ways the affirmative could go about this is going to invigorate certain fringe news organizations that have become increasingly mainstream recently. So groups like Breitbart, right, which is one that showed up in the media a lot, right, is often associated with pretty fringe alt-right politics, which can be associated with some really harmful racism, some really serious Islamophobia, and things of this sort. And there seem to be arguments that on this resolution, by affirming, we would be endorsing a model, for instance, in which they would get special sorts of protections or special sorts of privileges. And we might think granting these privileges would be a way to legitimize these fringe organizations and give them a platform to more effectively advocate for these hateful ideologies and dangerous ideologies. And so there are arguments that trying to affirm the resolution in the current political climate will get co-opted, right, or will get abused by these fringe organizations as a way to increase their power. And that those sort of impacts would be really, really serious and things that we should try our best to avoid. So, that brings us to the end of what we thought were the most interesting and central arguments on the topic. But you may have found other things. You may have questions about what we've said so far. So, questions? We have till 30?
Yeah, it's right.
Up here in the front of the red shirt.
So a friend of mine brought up Guantanamo, like AC, to where like in like aspects of Guantanamo Bay, they're like reporters that like report abuse, but if the prisoner itself is the one that gets caught reporting that abuse, they would like end up being punished severely. But Guantanamo Bay is in Cuba, but they're reporting in the United States. So in the aspects of foreign policy, what are your thoughts on that specific AC or
I think you actually find surprisingly good evidence that Guantanamo Bay is considered United States for purposes of legal sovereignty due to the like weird and precarious relationship between the U.S. and Cuba on that particular issue. And so I think you could argue whether or not it's in a U.S. court that Guantanamo Bay might actually be considered U.S. itself because it's like literally a U.S. naval base. Back there.
So how would you structure your Islamophobia critique? And also, do you think it's possible to run Islamophobia, like a Islamophobic critique on the app or no?
As far as the affirmative, I think perhaps. Like, for example, we discussed earlier when we were talking about the line drawing problem of who is and is not a legitimate reporter. You might argue that that sort of delineation relies, so the negative might argue that that sort of delineation relies on a distinction between legitimate and illegitimate news, and that's bad. And as the affirmative, you might want to say we should be drawing the line at what is legitimate and illegitimate news, and that treating everything as equally legitimate news might be the sort of thing that legitimizes, say, obviously false or ridiculous claims made by very, far outlandish alt-right organizations, things like that. And the indistinction between legitimate and illegitimate news might actually itself be a problem. That's the argument that comes to mind on the affirmative. Beyond that, I will say, by the way, we didn't mention this. Sunny Simon also helped a lot with this presentation. She wasn't able to be here because she's very sick at the moment, but she did a lot of the research in the literature, so she'll probably give you the best explanation of the Islamophobia literature because she's the one who read that and converted to us. So I'd certainly suggest talking to her as well.
You should. She mentions for the negative, an important link I forgot to mention is that confidentiality of sources can make it difficult for people to trust news sources. So when we say things like, a confidential source has said this about Trump, right? It's been very easy for groups to be like, why are all the sources saying anything about Trump confidential aides? We never know who they are. The media is just making these things up. And so the argument is that a rise in confidentiality in general has had an impact of delegitimizing news sources overall. Yeah. And then you'll need an alternative to get uniqueness. So you should ask Sunny about that because she has better ideas than I do.
Any other questions? Raise your hands high.
How would you respond to the sources right counterclaim?
Say that louder.
How would you respond to the sources right counterclaim?
So a few arguments. So one thing you'll find in the literature is that it is in fact not especially consistent with the current legal precedent of most of those lower court decisions we're talking about to vest the right with the sources. Because they're going to argue for a reporter's privilege, less so usually on the grounds of we're violating the rights of the informant if we disclose it. And the problem is that, say, that potential criminal or whistleblower has a right to the confidentiality themselves, but in fact the right comes from our general belief in the value of the free flow of information. And the courts are going to rule on grounds like this is a good principle for protecting the flow of information which is valuable in our society. And so if you view the thing that is being harmed not as some sort of like intrinsic trust that is within the informant themselves, but the ability of the information to spread and disseminate, then you might think is actually more accurately vested with the reporter, whose job it is and whose profession has been staked on spreading information. And that, in fact, they are the ones with both the most legitimate claim and the most expertise to decide how most effectively to disseminate publicly relevant information. Think about the value of the freedom of press. It's not the same as the freedom of speech, and like the reporter individually needs to share their views. We value the freedom of press in large part because it creates the ability of the public to get access to information that otherwise would be kept secret by, say, government officials or other groups. And it's that general value of the public sphere that's being violated, and therefore it's not a question of individual rights so much as a question of public's ability to know, and that gives one argument. Another thing is, you could also argue, I think, potentially, that this does rely on a particular conception of what a right is. Obviously. And so you could argue, for example, if you conceive of rights differently, then there could both be obligations and parts towards the reporter and towards the source, and those two things are not exclusive of one another. And I think there might be fruitful challenges in that direction.
We will put up all the articles we've been looking at into the Google Drive later tonight once we have time to compile them all. But one of the articles just on this question we found that's kind of helpful for the affirmative is who owns the journalist privilege, the journalist or the source, by Kurt Wimmer, W-I-M-M-E-R, and Stephen Kiehl, K-I-E-H-L. So who owns the journalist privilege, the journalist or the source? And that's a pretty long defense of the claim, just of the claim that journalist privilege is owned by the journalist.
In the very back there? I couldn't hear that. Sorry, can you say that again?
A police informant?
So I guess the relevant question is going to be, are they talking to a reporter in this scenario? If they're informing to the police, then I think the place where that's going to run aground is it won't be a reporter in the first place. And so even if reporters have the right, then it would be irrelevant because it's not a reporter getting the information. Does that answer your question? Okay. In the blue.
Are reporter and journalists equally interchangeable?
This is a really important question, which I've been wondering about all day. The correct answer to this question is yes. Have I yet found a piece of evidence that says that clearly? No. But, yes. For instance, if you look up the Wikipedia article, reporter's privilege, it says, reporter's privilege, also called journalist privilege, also called newsmen's privilege, which is a term you'll find if you want to find articles written in the 50s and 60s, use the term newsmen's privilege, and you'll find a lot of stuff about it. So yeah, it definitely is the same thing. This is, I think, important because there's actually a huge amount of topic civic literature about who counts as a journalist as it relates to journalistic protection, and a lot less talking about who counts as a reporter. Like, the term just amongst the people doing the topicality literature is always journalist. And so you do need to be able to win that all those articles do apply. And I think the correct answer is yes, though I've not yet found the evidence that says that. Yeah.
So you talked about earlier it should be a society or community's right to know?
I believe there is an argument for this.
And I was just wondering, like, what you meant by that, I guess.
Okay. So, if I steal something from Jacob, he can choose whether or not to press charges. Similarly, if I am driving and I run over his mailbox, he can be like, I'm going to press charges, Marshall, you have to repair my mailbox, or not press charges. But there are some things that I can do which Jacob does not have the right to press charges or not. So if I murder Jacob, right, then Jacob's family can't be like, we're not going to press charges, we're just going to let it go. The thought is that the government has the right to prosecute even if no one associated with Jacob wants him to. Right? Similarly, if I seriously maim Jacob and like torture him for hours, Jacob can't be like, Marshall's a nice guy overall, he was having a bad day, it's fine, I'm not going to press charges. The state will prosecute irrespective. This is one of the distinctions between like civil and criminal law. So broadly speaking, this is a way to think about the distinction. Namely, some things I can do to Jacob, and Jacob is the one who controls the claim that something should be done about it. But another view is that actually it's society. When I murder, I'm not wronging Jacob. I'm doing something to society as a whole. I'm breaking down the rule of law, right? And in that sort of situation, you might think it's society that I'm doing something wrong to. In the same way, if I speed, right, maybe it's society that I'm doing something wrong to. And if that's right, you might think that there are arguments that say society is the one who has an interest in freedom of press and freedom of information. I know for a fact that some of the literature on formal theories of rights, so like rights theory literature, talking about like interest versus will theories of rights, talks about the particular case of freedom of press and who, if it's the press has the right to freedom of press or society has the right to freedom of press. And I believe I remember there being talking about confidentiality in that literature base, but I haven't read it in several years and wasn't able to find the articles today when looking for them. But I've emailed the political philosopher who I know knows about this, and hopefully he will message me back soon, and I'll be able to update us with like particular evidence on the question.
Any other hands?
We've still got a while, like 15 minutes if you have questions.
I'm glad we covered every conceivable ambiguity about the topic in only an hour. Surely I'll have some questions. Yeah.
Is there a T or I guess controversy on the controversy word in the resolution?
On controversial, or wait, wait, you mean confidential?
Sorry.
So there very well could be. You'll find that different states, for example, define what counts as a violation of reporter's privilege differently. And so one thing they might define it as is merely evidence that was gained or information garnered after an exclusive agreement of confidentiality. For example, if you're like cooking meth in your basement and you're like, hey, come in, and I look around and then I walk away, but you never told me, hey, by the way, don't tell anybody about this, then some states are going to say the reporter has the right regardless, but some states are going to say it's only confidential information. If we explicitly agreed, you're like, hey, by the way, I didn't show you this, and I'm like, gotcha. And then that sort of informal contract is what constitutes confidentiality. And so you might find some literature that defines different little thresholds regarding that. I'm not sure which different affirmatives that would be relevant to, but potentially.
There's also a decent amount of literature about how we treat non-confidential reporting. And so, for instance, there have been several Supreme Court cases about whether or not non-confidential reporting has any sort of claim to privilege, and the answer the Supreme Courts have ruled so far is no. But there's certainly literature there that might connect in with the affirmative and raise questions about affirmative solvency and things of that sort, depending on what the affirmative is.
In the back there?
Yeah, follow-up question on the confidentiality. How do you, like, how does someone verify confidentiality? Like, would people have to listen back to the tape and hear, like, their part, hear, like, or their, like, I just don't know exactly how you can confirm that something's confidential unless you hear the tape and hear someone say, this is, like, off the record.
Yeah, that's a good question. It might be hard to verify. One thing to note, though, is that verbal contracts, even without like a paper trail, can be enforceable in the law. And so you might argue that, like, if both you and I have agreed, hey, like, we did say that, didn't we? And no one has any reason to doubt the matter, that the court still could consider that as a binding agreement, at least if they thought this was an important agreement, you know, in a world of the affirmative, even if we couldn't, like, proffer like a legal signature or something like that, or like a signed affidavit or anything that's like, yes, by the way, we did agree not to talk about our meth labs. That's my point, is it would likely just be a verbal discussion. It might be on tape, in which case that'd be great. You know, then the reporter could provide that tape if and only if it came up. But even in the absence of that, one could argue that if you have good evidence of a verbal contract, then that can still count.
So one way to make this point, I think especially clearly, is we're dealing with testimony of the reporter. If we don't think the reporter is telling the truth, the testimony doesn't mean anything anyway. So if the reporter is willing to just lie and be like, no, I made it up, there was no source, right? Or the source was Jacob Nails, right? We're already kind of in trouble as far as prosecutor, right? So I think there's a reasonable argument that we get to assume the reporter is telling the truth, because otherwise it doesn't matter if they're willing to lie, whether there was confidentiality at all. Yeah.
So like the point of confidentiality is that it's like the source tells the reporter only, and like only the reporter knows anything that like this encounter you had. So can't the reporter just claim that the source didn't say that the information was confidential and publish the source?
Well, so usually it's going to come up when the reporter refuses to do so. So for example, the reporter gets a subpoena, and then they go before the court and they say, I refuse to testify, and the court's like, but you gotta. And the reporter's like, I refuse. Well, and the status quo is going to happen, at least at the federal level for sure, and sometimes at the state level, is the reporter is going to be held in contempt of court, which can mean months or even potentially a short number of years in jail as a consequence for refusing to comply with the subpoena. And so these situations are going to arise when the reporter fails to actually disclose the information. And if the reporter voluntarily discloses that information, then it actually wouldn't be a relevant case, because even if you have a right to do something, you're not required to do that thing. And so whether you're in the affirmative world or the negative world, the reporter could always say, hey, y'all, here's what I heard. And that wouldn't be violating the right of the reporter to keep their sources confidential. Because the right of the reporter means something it's the reporter's choice to exercise or to waive. And so if the reporter chooses voluntarily not to exercise the right to keep it confidential, then there's not going to be a violation of that right in either world.
Can we say that then perhaps if lawyers or if reporters were forced to testify, that could promote false testimony from reporters?
They're just going to say someone else did it?
Or just if they don't want to report but then they have to, then they'll just maybe lie about what happened or protect their source?
Well, so here is the important thing, I think, in most cases is, so I, the reporter, have said, anonymous person, who, to protect the innocent, we'll call Marshall Schmompson, has been secretly making cocaine, he's been producing cocaine in his mother's kitchen sink.
In case it's not obvious, Marshall Schmompson is Lawrence.
Yes. That's the whole point of confidentiality. I'm sorry, Lawrence, that wasn't me. So, Marshall Schmompson, who could be anybody, all we know is somebody anonymous who has a pseudonym is doing this thing. I've already told the truth about everything but who it was. And so, if you're give me the name, and then I'm I refuse, and you're give me the name, I have a subpoena, and I say, oh, actually, that wasn't true anymore, you're probably not going to believe me. Yeah, and so the reporter fudging the details after the fact isn't going to solve the problem. And the reporter fudging the details in advance defeats the purpose in the first place, because they're reporting something that didn't happen that no one told them. So why are they even doing that? Who benefits from me just making up a story about some random cocaine producer? And so the issue is going to be, you already know everything except for who they're talking about. And then let's just say someone else. So it's just yeah, actually, Marshall Schmompson was Marshall, and you're that's ridiculous. And Marshall's that's ridiculous, I wasn't even anywhere near there. You're obviously going to know that I was just lying about that person. So I guess it's possible. Maybe you can find good literature on this, but it strikes me as a little bit hard for reporters to just name a random person. Especially because if they get caught, as they probably will because there's no evidence for that random person they named, then they're going to be guilty of libel or slander. And then they'll have a whole legal issue on their hands.
Also, poor random person.
Yeah. Yeah, poor Marshall is getting pegged for Marshall Schmompson's accent over there. You don't want him to go to jail for making cocaine when he didn't actually do that. Other questions? Yeah, in the front.
Would you like me to explain civic republicanism?
Yeah, so civic republicanism is the idea that the notion of what counts as freedom or independence in a society is more than just doing what you want or in your actions choosing the things that you wanted to choose. It's about the capacity to do so. And so you are not free just because you end up being able to do everything you wanted to do. So in the example earlier, just because Marshall ends up teaching a debate camp after he wanted to teach a debate camp and made that choice doesn't mean he freely chose that. If there was me pointing a gun at his head saying, you must do the thing you wanted to do. Because it wasn't truly his choice to begin with. And so it's the notion that freedom requires not just the fact that I interfere with him directly. He's not free as long as I didn't actually put a bullet through his head. It was the mere capacity for me to arbitrarily interfere with Marshall's life. The fact that he knew that I had the possibility of pointing a gun at his head and deciding what he did if he didn't comply, that was the violation of freedom. And this is important because the civic republican notion of freedom is not the same as, let's say, the libertarian notion of just don't do other things to other people. But it also involves minimize the ability of other people to subversively influence your decisions. So if the state, for example, has huge amounts of unchecked power, imagine we're living under a completely authoritarian government run by Marshall Schmompson over here. Even if he happens to be a very good governor / cocaine producer /
philosopher king.
Yes, and he ends up making very good policies, and he doesn't particularly oppress anybody with his laws. The very fact that we're living in a society where one person determines what everyone is allowed to do itself would be a violation of the Civic Republican conception of freedom, because what you are allowed to do and not is being determined by the arbitrary and capricious will of one random person who you may or may not trust. And so it's that very existence of the capacity for them to interfere with your life that is the violation of freedom, whether or not they actually use it perniciously to make you do bad stuff. And so this can work very well on topics like this, where, say for the affirmative, you might be arguing that the value of reporter confidentiality comes from the ability of the press to act as a check against the government. We don't want this super mysterious bureaucratic state with super large amounts of confidential information deciding things for us if we have no idea what's going on behind the scenes. And the ability of the press to shed light on that and hold the government accountable keeps it in check. And so it reduces the capacity of the government to interfere, whether they are or not. We need to know for sure that they're not doing things behind the scenes or planning to do so in order to ensure that we are actually not being, governed in an illegitimate, illicit way.
We have time for a couple more questions, depending on how broad the questions are, or how slowly the questions are asked.
Anyone have ideas that you think we haven't covered yet and you want to share? Yeah, right here.
Like for civic republicanism, like what kind of what authors would you need to know about that stuff?
So the big author for the framework that'll defend civic republicanism is a person named Philip Pettit, P-E-T-T-I-T. And that's probably the main source, and you'll find a lot of secondary literature, but all of it will probably cite Pettit. And so that would be the best starting point for finding the evidence defending that theory of government.
Also some Roman Stoics like Seneca and Rousseau and some other, medieval ancient philosophers defend Roman-style republicanism, which I always recommend reading.
Yeah.
Can you explain the right versus a right and the
Yeah.
associated with that?
So let's say there's a table here and there's one apple on it. And I'm like, the apple's on the table. That seems true because there's exactly one apple that's on the table. Now let's say there's a bunch of apples and no particular apple is distinguished from any other. And I say, the apple is on the table. That sentence sounds strange and not, at least not clearly true, because it implies that there's a particular apple on the table. And there's no reason to believe that's true. There's not even a particular apple to begin with that I'm referring to. And so it would fail to be true because there's not even a definite apple to be referred to by that sentence. Now let's say we've been talking about an apple. I was like, hey, where'd your apple go? And you said, the apple's on the table. And I'm like, oh, there's your apple with all the other ones. That could still be true insofar as there was a clear, specific, definite apple. Now, applying this to the resolution, that means it's not sufficient for the affirmative to show that they're discussing a right to confidential sources. Because if there were many different separate rights to confidential sources, e.g. in the banking sector, and in the national security sector, and in the environmental sector, and in all these different areas, and the ethics one amongst many, that's like referring to all those apples on the table and saying, the apple. It wouldn't make sense, and you wouldn't be talking about the same thing. And so you want to argue, I think, say as the negative, that the term the right implies that the affirmative is discussing holistically one overarching right. And if all they're trying to do as the affirmative is pick one right amongst many, e.g. a narrow instantiation of a broader right, then what they're discussing is a right to confidential, to protect the identity of confidential sources, but they're not discussing the right. The right implies that it's a clear, singular, definite one, which could only be true if it is the overarching right, or if it is the only right to confidential sources. And if they fail to show that it's the exclusive right that they're referring to, then they're not referring to the right at all. So now if that picks one example amongst many and says, many examples of confidentiality might be justified, and I'm going to defend one of them, we failing to show the right exists. They'd be showing a right exists amongst others.
I'm sorry, but would you mind re-explaining the sources right counterpart and how to respond to that?
Yeah, so one argument I mentioned a second ago is you can argue that there's good reason that it is in fact the reporter's decision or ought to be vested with the reporter. And one reason to think that is, if you look at some of the case law with these lower level courts and state decisions, they often justify it less on grounds like we're violating the informant's rights if we reveal that information, or a notion that the informant has like an absolute right not to have their meth lab revealed. But in fact, the harm that is being caused in a world where we fail to protect confidentiality is a harm to the flow of information. which isn't a harm to the informant specifically, it's a harm to society writ large. And therefore, it is better to vest that decision or consider that right as the right of the reporter, because the reporter is the one who's acting on behalf of the press and on behalf of society to disseminate that information. And therefore, it is less of a right of the specific individual to not have their information revealed, and more of a right of society to make sure confidentiality still exists, such that the free flow of information can still happen, which means it makes more sense to keep it in the reporter's hands.
Oh, all right, these are the last two questions. Yeah. And then you in the back. What?
Oh, she asked you the link to the Islamophobia argument.
Oh, so there are, I think, two links that are possible here. One is that confidentiality in general has made it difficult for people to trust mainstream news outlets. And this has sort of increased the impression like, oh, all news is fake news, right? It's always like confidential White House sources. That means nothing, right? They're just making things up. And this is increasing the power of alt-right groups, which contribute to Islamophobia in society. The second argument, I think, is against AFs that defend a fairly inclusive definition of journalism. The idea that this would require us to give like journalistic credentials to groups like Breitbart. So there was a lot of objections, for instance, when the White House gave Breitbart access to the White House briefings, when they credentialed them as journalists. They were like, that's ridiculous, they're not journalists. Because this was seen as legitimizing a particular form of political advocacy and news advocacy, which we don't want to legitimate as actually serving the public interest in news, because it's racist. And so the thought might be that similarly, if we were to grant legal protections, we'd end up the affirmative ends up granting legal protections to groups that have the sort of alt-right politics, and that gives them the sort of credentialized legitimacy, which increases legitimacy of fringe anti-Islamic programs and movements in the United States.
And one final question?
It was
who'd you say?
It was you. Yes.
Well, okay, so if you say that it's the reporter's right to keep their source confidential, doesn't that kind of imply that the reporter also has the right not to make their source confidential, even if the source might question it?
You're asking if the reporter could waive that right? Yeah, it most likely would imply that.
Yeah, so, but also think this is, at least kind of intuitive, right? So suppose Jacob's a reporter, and I, just trash his room, right, one night. I, burn all the furniture and things. And before he gets back, he's like, Jacob, I know you're a reporter. I have confidential information to tell you. I'll tell you on conditions of confidentiality. And he's like, okay. And I was like, I just destroyed all your property. Can't go to the police now. That'd be a weird thing to be able to do. And so you might think it's actually pretty important that Jacob has the ability to waive this. Another example of this that was kind of recent. I believe there was this group back when doing one of these runoff elections, and it came out that some politician in Alabama or somewhere was a really, really bad person. There were people who were trying to trick news organizations. They were coming up to me I have a story about how this person assaulted me. Are you going to publish it under conditions of confidentiality? And well, maybe, let's try to figure it out. And they found out it was all kind of a lie, right? If they could not sort of break that confidentiality agreement on the realization that it had not been good faith, then that could have been kind of bad. And so there might be reason to think it's actually not a bad thing, as long as reporters are on it, right? As long as reporters have integrity. And reporters have pretty strong incentives to maintain integrity, because they want other confidential sources in the future and things like that. That's actually a pretty good system to have. Because in general, right, if I tell Jacob something, it's probably, in general, probably the case that he should not be bound in what he can reveal, but legally. If Jacob promises me something, the law probably can't make him keep his promise. That'd be a bad idea. And probably the same thing is arguably true for reporters. All right, cool. So that's the end of the topic analysis. Next up is Saki's hours.